Hello everybody, I am Sam Broadfoot QC and I'm a specialist in public law across a range of areas and part of the Landmark Chambers education team. And welcome to our seminar or our webinar this afternoon on off-qual and appeal rights. Those of you who either know me or came to our previous webinar on this topic back in April may remember our concerns about the assessment process, in particular the lack of detail on the standardization proposed by the statistical modelling which was suggested. And you will remember that the statistical modelling, which is aimed to provide a standardised process, has 5 aims, and these were to provide candidates with the grades that they would most likely have achieved had they been able to complete their exams in this summer just gone, to apply a common standardization approach within and across subjects, to use a method which is transparent and easy to explain wherever possible, to protect all students from being systematically advantaged or disadvantaged, and to be deliverable by exam boards in a consistent and timely way so that the results could be quality assured and could be effectively overseen by Ofqual. As you will all know, there was a consultation on the various proposals relating to the way in which grades should be awarded, and this consultation provoked an enormous number of responses, over 12,500 of them. What is very interesting, but perhaps not surprising, was the number of personal responses. Some 11,000, including nearly 4,000 teachers in a personal capacity, nearly 2,000 individual students, and over 4,000 parents or carers. I think those sorts of results might actually be unprecedented. In the usual way, as when there's been a big consultation, there has been a consultation response document containing the Ofqual's analysis of the responses, and summaries are included in it. However, even without listing all the organisations that responded, and there were many, this document runs to 108 pages. It makes fascinating reading, and points were made by people, and including students, that I hadn't even thought of. And it demonstrates quite how difficult, maybe even impossible, it will be to achieve all of the stated aims. And one of the highly articulated and repeated areas of concern related to the standardization process. And for example, one student stated that it would not be fair towards many students, as it would not consider individuals on a case-by-case basis, meaning that there is a high potential for students to be negatively impacted by this. And somebody else responded that historical data may not reflect an accurate picture for some individuals. And there were lots more things in that vein. Now, the details of the algorithm have not been disclosed. Whilst there's been quite a lot of discussion on social media and in specialist publications about whether that is lawful, there has as yet been no challenge to it. And insofar as the failure to disclose the algorithm meant that the consultation process was flawed, I can well imagine Ofqual's initial and forcefully made response that that ship has sailed as a result of the passage of time. Whether or not that is so, obviously, may yet need to be seen, but one can expect that response. But the difficulty, of course, is that here we now are, and no one knows what the algorithm has actually done to the grades assessed by the teachers and sent in by the schools. So what happens next? And not everyone, obviously, will be adversely affected by the algorithm. Indeed, the very least one can hope for is that most people will be awarded the right grade. Where right, in this context, actually means fair. But that brings us then on to the appeal rights. What are they? Who can appeal? What are the grounds of appeal? How long have you got for appealing, and what other avenues might there be? Luckily, I am flanked virtually, of course, by my excellent colleagues in Landmark Chambers' education team, who will be answering those questions. And there will be a question and answer session at the end. So please put your questions in the chat function, and we will try and deal with as many of those as we can at 5:30. And if any of them are too difficult, I'm going to ignore them. So think about it in due course. So first up is Ben Fulbrook, who, despite being still quite junior, has in fact done several education cases, including a case involving judicial review in relation to an academy and a judicial review against Ofsted. And so he is going to kick us off with who can appeal. Ben, over to you.
Thanks very much, Sam. I'm just going to take control of the screen. Here we go. Naturally, there's a bit of overlap between some of these topics, and it's quite difficult to talk about who can appeal without saying something about their appealing and what their grounds would like to deal with it. But first of all, I just thought Sam's done some great background there, so I don't really need to repeat it. But in a nutshell, the way that exams are going to work this year are that the centre will predict student grade and rank the student within their cohort. They then submit that data and the relevant supporting data to the exam board, which then apply their statistical model that Sam was discussing, taking into account, which basically takes into account details of the centre's previous performance, and then the exam grades are issued, and it's only at that point that the question of appeals arise. And I've included in those 2 bullet points there a couple of links to what are, I think, relatively helpful documents that Ofqual produced. The first is the consultation decision document, and the second is the subsequent guidance from Ofqual. And it's also worth saying that this is still a fluid situation. We just still have definitive guidance that should be released fairly shortly, but it hasn't come out yet. So this is the best that we know at the present time. So who can appeal? I think there are 4 different issues that this raises. So the first is, can a student appeal against the professional judgment of the centre in assessing their predicted grade and their rank? Can the student appeal against the process or procedure adopted by the centre? Can the centre appeal against the decision of the exam board? And can a student appeal against the decision of the exam board? They're the 4 questions I am going to try to answer. So question 1, can a student appeal against the professional judgment of the centre? To explain the pie chart, you can see that that's taken from the analysis of the consultation responses. As Sam said, there was a huge number of consultation responses. But what I've slightly done wrong there, it's a bit confusing, is that pie chart doesn't exactly answer the question above it. So that actually answers the Ofqual's suggestion that students should not be able to appeal against the professional judgment of the centre. And you can see that opinion is pretty closely split there. So the responses in the kind of shades of green are people saying no, students shouldn't be able to appeal against the professional judgment of the centre. In brown, it's people on the other side. So a really even split. I mean, some of the issues were raised is that there are there's no common benchmarks, and for the exam board to adjudicate such an appeal like this would be very difficult because it can't compare one school with another very easily. Students are obviously concerned that they should have the right to appeal against the grades that they've been given. Staff and teachers understandably concerned to protect their staff and protect against the delay and the administrative burden that might arise if appeals were invited for all of these decisions. So that was some of the debate, and the answer that came back was no. A student can't appeal against the professional judgment of the centre, and you can see that quotation there. That's from the guidance that Ofqual has issued, which says just that, except note the bits that I've underlined, which is that there's a slight caveat to this, which is where a student can present clear evidence of bias or discrimination, then they can pass that evidence on to the exam board, who could investigate for potential malpractice. So that's not direct appeal against a decision, but in reality, that is a route that you could take. But clearly, something like that's not going to be, you're not going to be entertained without clear evidence. The next question is, can a student appeal against the process or the procedure adopted by the centre? So not so much the professional judgment in saying, we think you're working towards, grade A, but rather the process by which the school has gone about ranking students and gathering the data that it's producing to give the grades. Again, the pie charts really flip the wrong way around, because it's a consultation on the suggestion by Ofqual that students should not be able to appeal against the process or procedure, and you can see a fairly even split, but actually majority of people disagreed with the proposition and thought that students should be able to appeal against the process or procedure. But again, the similar arguments are raised that the procedures aren't standardised, so schools are able to adopt which the sorts of procedures that they think in their judgment would work best for them. That an appeal of this nature given directly to students would undermine professional judgment, and it's quite difficult in the absence of standardised process. What would the basis of such an appeal be? And again, there was concern about the administrative burden of allowing appeals. So the answer that was given was no. Again, the student can't appeal against the process or procedure adopted by the centre, but what you can do is, if the school admits that it has made a mistake, so if maybe it's put the wrong data in for the student and submitted that to the exam board, the school can appeal on behalf of the student on the basis that the school made an administrative error. And I've put C below that because I'll talk about that a little bit later. The next question then, can a centre appeal against the decision of the exam board? You can see there's quite a strong consensus there that the centre should be able to appeal against the decision of the exam board. But when I say decision, it's important to note, and as Yas will talk about in more detail, that means appeal on the basis that the centre used the wrong data, or the wrong data was used, or the grade was incorrectly communicated and calculated. As you can see, most people, there's very strong support for this, and the only concern was that schools could, some centres could exploit this sort of route to basically seek a general review of their grade, so they could identify some incorrect data in one of their students' grades that they've submitted, appeal on that basis, and use it to force the exam board to review the way it's dealt with all of their results, in the hope that they could push them up. So there was some concern raised about that in the consultation response. The answer, unsurprisingly, unfortunately, was yes, the centre can appeal on those grounds. So on the grounds that they used the wrong data, calculating grades, etc. But they decided to add a caveat, which was to clarify that where a centre makes an error in the data it's submitted and wants to appeal on the basis that it submitted the wrong data, that there must be clear evidence that the error had actually been made in the centre. Because the concern was the centre might say, well, we've made an error, we should appeal and get the review. What this guidance is saying is that if the centre needs to show that it genuinely has made an error in this case, and before it will entertain an appeal. And then there's this further point about demographic changes, so that there was an outstanding question after consultation about what would happen where a school could show that the cohort at its centre had changed so significantly that the statistical standardisation would not produce a fair result, basically. And it's been agreed that in those cases where a school can demonstrate that, then the centre can appeal on that basis, provided that they can show the evidence of it. So, but again, I think that will be discussed in more detail later. And then finally, can a student appeal against the decision of the exam board? You can see a fairly even split there. Lots of students said obviously they felt very strongly that they should have a direct right of appeal against the grade that they've been issued. They felt that it's their grade, and so they should be allowed to challenge it. And that there's something. People said it seemed a bit odd that a centre, which is effectively deciding, or to some extent deciding the grade, should be the only person that can then appeal it. But of course, it is normally the process that it's the centre that brings the appeal on the behalf of the students. And the answer to that was no-ish, by which I mean a student cannot directly appeal their result. So the centre will appeal on behalf of the student, ensure that centres provide for students to appeal within the centre. So if the centre decides not to seek an appeal on behalf of the student, or to seek any additional information, the student should have an internal right of appeal against that decision. And you can see there that additional guidance makes clear that schools should put in place a procedure for that and communicate that quite clearly. So in summary, very briefly, the answers are: students have no formal right of appeal against the professional judgment or the processes adopted by their centre. They have no formal direct right of appeal against the exam board, but they may appeal through their centre, and they have an internal right of appeal within the centre if the centre doesn't decide to seek an appeal on their behalf. And those are, I hope, as far as we can tell at the moment, the answers. And that is me. And I think Corinne is now going to take over.
Thanks very much, Ben. I apologise to anyone who didn't manage to catch every word of what Ben was saying. There's been seems to have been a slight issue with the internet connection, but hopefully that will be all right now. Karine, by way of introduction, Karine regularly appears in the First Tier Tribunal, the Upper Tribunal and the High Court on education matters, ranging from special educational needs to admissions, exclusions, etc., as well as disability discrimination claims on behalf of children. And she's the author of the Education Chapter in the Human Rights Practice publication. Thank you. Karine.
Thank you very much indeed, Sam. So I'm going to be talking to you this afternoon about time limits. Now, you might think that might result in a sort of one-sentence talk where I just tell you what the time limits are and then we move on to the other talks. But it's been rather more difficult to ascertain exactly what's going on in terms of time limits. Let me explain why. As Sam has already said, we are still awaiting the final guidance on all these issues. And the guidance which is online is distinctly unhelpful and in some respects contradictory, but we've done our best to try and ascertain what the time limits are, and I'll explain where we got to. Now, normally when you are bringing in when you receive a grade as a student, there are two routes of challenge. So normally, as I've set out on this slide, there is, so much as the present system is for 2020, you cannot, as a student, directly appeal your grade. You have to ask your centre to challenge the grade you've been awarded. And there's a two-stage process. First is a review stage, whereby the student can ask the school or college to ask for the qualification result, i.e. the grade, to be looked at again. And had there not been COVID, the deadline for requesting a review would have been the 17th of September. And then Ofqual effectively let you know what's happening, and they let you know why the grade hasn't changed if it doesn't change. Now this part, this is the usual process in a non-COVID world. This part of the procedure appears to have gone, and there is now only an appeal process, i.e. you as a student have to ask your centre to bring an appeal. This review stage appears to have gone, although it appears to have been introduced at a later stage, which I'll explain in a moment. But the deadline remains the same for appeals. So 17th September 2020 is the date you need to have in your mind. That is the date by which, if there is to be an appeal, you as a student must have requested it, and then you as a centre must have requested that appeal on behalf of a student. It looks as if, although the final guidance has not yet been published, it looks as if that will be the deadline, and after that no further appeals will be looked at. Now, again, the second route, this is the normal process, is that normally if you got the results of a review and they hadn't changed your grade, you would then have a proper right of appeal. The centre would have a right of appeal, so the student would ask the centre, and then the appeal would have to be brought within 15 days of getting the review result. That process appears to have gone. It's a one time limit situation now. As I've said, I've given you already the date in September, but it doesn't look as if there is another 50 days. So although the government website still suggests that that is a two-stage process, that doesn't look as if that's going to that's in existence anymore, at least for this summer. What does that mean in practice, the 17th of September? Well, the truth is, I think, unless, of course, people are going off for a gap year or there is some other reason why they can delay the final grades they get, it means in practice that you must get your review request or your appeal request into your school or centre as soon as possible. Those who are homeschooled, and I'm sure other speakers will be speaking about this, but they can request the review or now appeal directly, but don't wait till September unless time doesn't matter. There is likely to be a flurry of appeals because not everybody understands the process, for a start, and secondly there are likely to be, as there always are, a significant number of people who are not happy with the grade that they receive. So my practical advice would be, even though you've got till September, really appeals should be going in as quickly as possible. And as Ben has already said, if your school or centre refuses to put in an appeal request, you can't ask for it yourself as a student or on behalf of a student, i.e. a parent, but the school will and it must have a complaints process, so an internal appeal process by which you can ask for that to be done. But again, in terms of time limits, not all schools will be entirely up to speed with the guidance. It is really important that it is impressed upon them that whatever their system is, so if a student applies or requests an appeal in school or centre says no, it must be impressed upon them that any internal complaints procedure must be wrapped up well in advance of the 17th of September deadline, because otherwise they're just going to miss the boat in terms of making the application for an appeal. I said I would come back to the fact that there might still be a review process. One of the student guide documents, which is available to students who are seeking advice from government as to what their appeal rights are, suggests that even after an appeal has been refused, there is something called an off-call exam procedure review service, which would look to be some kind of further review even after an appeal has been refused. There is basically no detail on this at the moment. I don't know whether the further and final guidance will clarify that, but and certainly they haven't published any proposed time limits in respect of that. It may well be that that only deals with bias and discrimination cases. We just don't know yet, but it's something to look out for. And the only other thing which I think I needed to say is that, hold on, not moving my, Oh yeah, is I wanted to speak to you very briefly about NVQs and BTECs. They're different from A levels, AS levels, and GCSEs. They never had a request for review. That was a direct appeal to the exam board by your centre body, and then there is an appeal. There is a formal complaint to Ofqual thereafter. And I've given you a link to BTEC appeals. That appears to still remain in place. So it doesn't look as if the guidance in respect of NVQs and BTECs and other vocational qualifications has changed. Again, updated guidance may tell us differently, but that doesn't seem to be to have changed, and there is obviously no time limit in respect of bringing a formal complaint to Ofqual in due course. I think that's it. Thank you very much indeed.
Thank you, Carrie. That's really helpful. So the next talk is from Yasa. Yasa is going to talk to us about the grounds of appeal that are open according to the regulations. He has acted for various parties over in the past, including local authorities and schools, on education issues, and recently acted in a £10 million challenge to the Secretary of State's allocation of basic need funding. So Yasa, tell us about grounds of appeal.
Thanks very much, Sam, and good afternoon, everyone. Thanks for being here. So you've had who can appeal, you've had what the time limits are, and now, as Sam said, I'm going to be talking to you about grounds of appeal. On what basis can you seek to challenge an awarded grade? And for those of you who read previous consultations and guidance, you will know that they really are quite limited. There are essentially 3 grounds of appeal, and they are exhaustive and they are narrow. And in summary, you can argue that the awarding organisation used the wrong data. I'll come in a moment to discuss the various types of wrong data that this could relate to. You can also argue that the awarding organisation made an administrative error in issuing the results. And finally, you could argue that the awarding organisation was guilty of procedural failings. And we already, Ben has already looked at things you cannot appeal, so I'm not going to go into those in any more detail. So focusing on the top 3 of those, most important will be the wrong data lim. And there are various potential types of error, 3 main ones, and then an exciting miscellaneous category. More on that one later, but the other ones can be summarised as the centre itself providing incorrect information, the awarding organisation using an incorrect data set, and the awarding organisation introducing an error into an otherwise accurate data set. So let me look at those in turn. Now this is the school itself making a hash of things. What kind of error? Well, you get the names of your students mixed up. So sorry AQA, we have a Leon Glenister and a Glenn Leonster, and we mixed up their results, very sorry. That's the kind of thing. Or apologies LXL, my handwriting is really bad and I typed it up incorrectly, so that the 6 we awarded should actually have been 9. But crucially, this does not allow centres to revise their professional judgments. You can't change your mind on someone because over the summer, over a few weeks, you decided actually they deserved a higher grade. It's not those types of errors that are catered for. And in order to make sure that schools don't do that on the sly, the awarding organisations are going to be quite strict on the evidence you provide. So in other words, the school has the burden of proof of showing that it made a genuine clerical mistake as opposed to anything else. And if the awarding organisation isn't satisfied, then it won't do anything about it, won't allow the appeal. The next type of wrong data, so remember this is still the first ground of appeal, but the second type of wrong data that you can rely on for an appeal. This is where an incorrect data set has been used by the awarding organisation for the purposes of its statistical standardization. So when using historical data, the awarding body used past results of Tiffin Girls' School when awarding grades to Tiffin School, i.e. the boys' school. And now that would be a pretty fundamental error, not least because the girls' school is much better than the boys' school, but also because it will affect every single student's grade at that centre. But it also should mean that it's quite straightforward to spot. So that's quite a fundamental error that realistically is going to be hard to see happening very often. And then the sequel to that is errors within data sets. And just recapping for a moment, awarding organisations will be using various types of data to standardise grades. That includes historical results and prior attainment data. They'll be using centre assessment grades and rank order information as well. Now, this sort of error that we're talking about on this slide focuses on the situation where the awarding body has the correct data set, but for whatever reason, it's made an individual error when transposing that data. So when it came to look at the rank order, it mixed up your Glenn Leonstow with Leon Glenister. And we're also told that where it emerges that the actual error emanated from the school, so the awarding body looks through its archives and asks why the error was made or if an error was made. If it discovers that it was the school that actually had made the error, an appeal cannot be brought where there was a pre-existing error in the original historical results or prior attainment data, or if particular students were not matched with their prior attainment data for the purposes of standardization. So that's that type of error. And then the exciting category, my favorite, the miscellaneous category. Now, the three previous categories we've looked at were not exhaustive types of wrong data. There may be other types of wrong data that can form the basis of the appeal. And this is where the miscellaneous category comes in. And Ofqual flags this up, but does say it will involve exceptional circumstances where there is some exceptional factor which undermines the assumption that the default data set is the most likely to lead to consistent results. Now, there's going to be a very high bar for this, requiring clear and objective evidence of a substantive difference. So here you say, what will not be exceptional? Well, probably most things, by definition. You will not be able to argue that this year's cohort has greater potential than last year's, as shown by their mocks or standardized tests. That won't cut the mustard. But what will, where something happened, is where something happened to the 2020 cohort or an earlier cohort against which you're comparing their data, which indicates that the 2020 cohort may not be comparable. And there are two possible but not exhaustive scenarios. The first possible scenario is where there's been a major structural change at the school. For example, a single-sex school has had a mixed intake in 2020 for the first time. Or another type of structural change where a school has an accelerated learning program for able students taking their exams early, and the school is entering them for the first time. So that's the first possible scenario, structural change. The second possible scenario is where teaching in previous years was significantly disrupted for a prolonged part of the academic year by one or more, and I'm quoting here from the draft statutory guidance, extraordinary or momentous incidents or events. Quite remarkable wording, actually. Basically, the World Cup being played in 2018 and everyone doing badly in their exams isn't sufficient, although arguably England getting to the semi-final was both extraordinary and momentous. But even if you could show structural change or disruption, significant disruption in previous years, even that's not enough, because you would in addition have to show that there is a way of standardizing results to account for the difference, and that this is more likely to be accurate than the default use of the data set. Overall then, not going to apply very often. So that's the wrong data appeal ground covered. The other two grounds of appeal can be dealt with very shortly by me. And so this is where a result generated by applying the process set out was incorrectly issued by the awarding organisation in respect of one or more learners. So that's paragraph 5.2 of the Extraordinary Regulatory Framework, General Qualifications, Conditions and Requirements. So in other words, the correct data has been used and the proper grade has been produced, but for whatever reason, there was an error in the final step of issuing grade. And frankly, there's not much more for me to say about that. It will happen or it won't. And then finally, procedural grounds. The awarding organisation did not apply procedures consistently, or that procedures were not followed properly and fairly. So just highlighting, this is the awarding organisation, not the centre. And I have to say that I'm not entirely sure what this envisages, and it's not expanded upon in any of the guidance. And it's obviously a separate ground of appeal to the wrong data ground. So it suggests that this ground of appeal may exceed even where correct data has been used, or we can't prove that wrong data was used. But if that's the case, then what will be the remedy, given that there will have been presumably no prejudice because the correct grade was arrived at. And actually, I'll be interested to hear what others have to say about that. So I think that's the end of my talk. I can now hand over to Sam and Leon.
Thank you very much, Yasser. That was excellent. Can I remind people to please do type questions or thoughts, indeed, into the chat function at the side of the Zoom screen. I know that there are some of you watching or listening who have got lots to say about this issue, and we'd certainly be interested in your thoughts or indeed any questions. So right, then going to our next speaker, Leon. Leon has extensive experience in education law. In fact, I think, Leon, that you wrote the Noddy's Guide to Special Educational Needs Appeals, I think, and he's ranked in education for both Chambers of Partners and the Legal 500 in this field. He has extensive experience advising and acting for students and schools in judicial reviews, as well as acting for the Secretary of State for Education on numerous occasions. I know that he has taken an active interest in the summer 2020 exam issue and has advised various bodies about that. He's also, in fact, a tutor at the University of Cambridge in administrative law, and this has formed part of his interest from a transition point of view. So, Leon, please talk to us about other routes of redress.
Thank you very much, Sam, for that introduction. Yasser's example about the name bungling is not completely without basis. I get about one email a month, I would say, which says, "Hi, Glenn," and I've never quite been able to work it out, but I don't know whether others have similar name issues, which just people get wrong. But anyway, so I'm going to talk for the next 10 minutes or so, maybe slightly more, on the other routes of redress. So we're now at the stage we're putting the appeal procedure to one side, which you've heard a lot about over the last 3 talks, and we're looking at what else can be challenged, either individually or systemically. There are 3 areas which I want to cover. Now on the screen. Firstly, I'll cover broadly taking exams in the autumn series, so that's one alternative for students. Secondly, challenging school predictions. So those are the predictions that fed into the algorithm, which then produced the mark. So challenging the school predictions, that's the first stage. And then lastly, challenging the standardization model. And I'll deal with those 3 sort of areas in turn. So firstly, taking exams again in the autumn. So this is the most obvious answer for most students. It's now been confirmed, and it was open to some discussion and doubt, but exam boards must make exams available in all GCSE, AS and A-level subjects in the autumn series. These are in the same subjects and the same format as the summer 2020 series would have been. So the idea is in-person exams, but obviously that is all slightly contingent on developments elsewhere and whether there's a second wave and how many people will come back from Spain. But that's the intention. The exam series, so it's in the same format, but there is going to be no non-exam assessment except in art and design. And the rationale for that was that some students will no longer be at school, so they will find it difficult to do non-exam assessment. And also different students would at different stages with coursework, for example, when lockdown hit, and it would disadvantage some students more than others. So the general rule is that there will be no non-exam assessment. Another point that was not clear and subject to some angst at the beginning, and a point that I emphasised strongly, was whether students could choose to take an exam in the autumn series and then essentially replace the predicted exam grade that they were given in August, and that is now been clearly set out. So exam boards will be required to replace certificates from the predictions or the August grades where a student requests that. So in terms of timing, the exams in the autumn series will run from October 2020 with some flexibility depending on circumstances, which I've already alluded to. This will obviously not assist necessarily those who are about to transition. Now, that is subject to wider discussion and guidance in relation to how universities are going to act and potentially sixth forms, which I won't go into here, but basically it's hoped that there will be contingency plans for those students, but that's the subject of another talk altogether. And there is, in terms of the autumn series, a document which is the consultation response, essentially, which I've set there at the link at the bottom. So that's the first option for students, or the first area of how to deal with matters if you aren't successful on an appeal or don't have the grounds. Now, the second area to cover is in relation to the school predictions. So can you challenge, you can't challenge it in the appeal, but can you challenge in any other way what the school predicted you? Now, what's important to note is that if you want to get your prediction from the school, you'll have to make a subject access request, and it's very clear from the guidance that you are not going to be entitled to that until after results day. And under the Data Protection Act, I've set out there the section, you can only get that, or there's only a requirement to provide that within 40 days of results day. So that takes you to sort of mid to late September, which is a real problem if schools are going to be delayed in dealing with these requests. So that's a practical problem up front. Now, looking at the predicted grades model, or the prediction model, as I've considered it there, or termed it there, this was considered by the Education Committee, the Parliamentary Education Committee, in a report, and it was published on the 11th of July, entitled Getting the Grades They've Earned. And now I really recommend anyone to read that who's interested in this area, because it's quite important and quite interesting. Now, the committee was conscious that there may be was conscious of unconscious bias, and this was the evidence that it received. Now, the Sutton Trust had produced evidence that low-income families are more likely to have their grades incorrectly predicted than more affluent peers, and high-attaining disadvantaged students are more likely to be under-predicted. And the same kind of trends were set out in evidence in relation to BAME students. And there were also significant concerns in the responses and the evidence it received in respect of SEN students, even the simple points like mock exams, did they have access arrangements? And so there was significant concern from the committee on these points. Now, what did the committee find? Well, the committee concluded that they were unconvinced that the safeguards, such as the additional guidance and practical recommendations put in place by Ofqual, will be sufficient to guard against the bias and inaccuracy in calculated grades, and it welcomed Ofqual's commitment to publish a full programme of evaluation in the autumn. Is that, however, too little too late in this respect? But it shows that there is a real issue about school predictions. Now, what can we do about that in a legal sense? Well, you can judicially review in theory the model that's been adopted, but my suspicion is that will be a very difficult thing to do because it's a bit too far gone. The model's been out for a long time, everyone's relied on it, it's going to affect a lot of students, so it's going to be quite difficult. And if there is going to be an evaluation in the autumn, which is going to be published, there is obviously going to be political consequences to it, and one wonders what a judicial review would add, which the political scrutiny isn't already doing. So what other options are available? Well, you can make a discrimination claim against the school if you, sorry, I've move forward. You can make a discrimination claim against the school if you can't in the appeals process. It's slightly up in the air, but if you make a discrimination claim against the school, that goes to the FTT. Now, you'd have to say that somehow the school's processes somehow discriminated against you. I think the two key points here are, firstly, I think proving discrimination will be difficult, not impossible, but difficult, depending on the facts. That's the first point. The second point is the practical remedy. So the FTT can't order your grade to change, and it can't order compensation. So you'd be looking at a declaration or apology, essentially, and one wonders whether in practical terms it would be a worthwhile pursuit. Now, if the last point is, or the last method of challenge would be the a discrimination claim against Ofqual, to say, well, somehow the processes in the algorithm discriminated. Now, again, it's hard to see what the outcome that wouldn't be generated from the public scrutiny would be achieved through a claim, and because the court wouldn't have the power to change the grade. It might, in this circumstance, be able to give a small financial remedy, but I think the court would be very cautious before embarking on that road. So in relation to the school prediction system, I think it is quite a difficult ask to launch a successful challenge. So we then move to the last of the three areas which I was going to discuss, which is the standardization model. Now, we've touched on this at various moments in today's talk, and the standardization model, as Sam said in the introduction, is not public. But the consultation response sets out the sources of data which are being used, and that's historical outcomes for each centre, prior attainment of this year's students, and those within previous years within each centre, expected national grade distribution for the subject, and data is going to go back 3 years. So this does address the concerns which were originally put about what if you get a standout year group. And in theory, that's been dealt with, because we now know that the prior attainment of this year's students are being taken into account. But what it still doesn't deal with is where an individual student has excelled in comparison to peers both in this year and previous years. So the answer, frankly, is they've just got to resit the exam, and that's pretty upfront in the consultation response. And essentially, of course, say we've tried our best to do what's fair for most people, and they will be the ones disadvantaged. So that is a real issue, I think, in the standardization model. The standardization model was considered as well by the Education Committee. Go to the next slide. It was considered by the Education Committee, who said more transparency is needed urgently, and it raised a few concerns. Atypical students, so high achievers I've just covered, small send providers who with a highly variable year-on-year cohort, and lastly turnaround schools who will likely be disproportionately serve poorer communities. And so they were the concerns about the standardization model, and the conclusions from that committee were that they were extremely concerned that Ofqual's standardization model does not appear to include any mechanism to identify whether groups such as BAME students, FSA, free school meals pupils, looked after children, SEND pupils are being systemically disadvantaged. And they also set out that Ofqual should be completely transparent, immediately publish the model, and should collect data on appeals. Now, what's happened since then, if we move on to the next slide. Well, what's happened, well, let's deal with first, is there a duty to publish the model? Now, there is a case called ESI and NICE. Now, NICE is the National Institute for Clinical Excellence, who provide guidance on drugs, and they they recommended that a particular drug was used only for patients with moderately severe Alzheimer's because that's what was cost effective. Now, what ESI said was, we want the formula on which you have based cost effectiveness. And what they got was the formula in a sort of in a plain way, without, they couldn't input any data to test the propositions that were being used. And they said, we need that as part of our consultation. And what the court said was, actually they did, that was required, because they were, NICE was discharging an important public function, and there needed to be an exceptional degree of disclosure and consultation. And there was a really good article by Jack Maxwell and Joe Tomlinson on this, and they rely on that case, and they say this causes and that's the proposition, that this causes there to be a duty to publish the model. So what has happened? Well, the whole legal argument frames on the gunning principle on consultation, that you need to be given sufficient reasons for any proposal to allow for intelligent consideration. Ofqual have published a short film and fact sheet, and there's a little YouTube video you can watch, and they have said they'll publish the details of the model that is used on results day. Now, when that comes out, is there going to be an issue? Is there a challenge? And the answer is potentially, because we don't know the model yet. Because publication now, or even on results day, doesn't answer the legal point that consultation wasn't fair because there wasn't sufficient information. So that's not an answer to the legal challenge. But I think what will need to be overcome is the timing issue, because the consultation occurred some time before and it's been relied on, etc., going forward. So there may be a timing issue which would need to be overcome. So bringing those points together now, looking first at the wider challenges that might arise from this whole summer series. Now, there was a claim being reported in The Guardian, I think it was being brought by Doyle Clayton, in respect of a sixth former who was appealing or bringing a potential judicial review in respect of the standardization model and appeals process. As far as I can see, there were insufficient funds to bring the claim according to the crowd justice page, so I don't think that's being brought. But what happens on results day, I question. If something similar happens in what happened with the International Baccalaureate, which some of you will have seen, essentially what came out was grades well under what students were predicted, and there was a furore, there was a 20,000 petition to consider it, and Ofqual are looking at that now. Could there be a potential legal challenge? Because at that stage, we'll also know the standardization model. It's useful to note, I think, and just to refer, the Ofqual as a statutory body, it was set up by the Apprenticeship Skills, Children and Learning Act 2002. And one of the objectives was to implement assessments which give a reliable indication of achievement. Now that's a target duty, and in section 129 it says, well, Ofqual have to achieve that as so far as is reasonably practicable. But the question is then how far a court will go in enforcing that duty, and that may well be relevant to what emerges on results day. There remain issues, even if there were breaches of duty or legal flaws. I think there remain practical issues. One is the timescales. In an expedited judicial review won't be heard for probably a few months at minimum, by which stage the autumn series will have kicked in already. So there's the timescales issue. There's the alternative remedy issue. Ofqual will say, well, your alternative remedy is going to sit the autumn series exam, and there'll need to be an answer to that. Practical remedy. Will the court really quash the whole system? Probably not. So we'll be looking at sort of cases on the margins if there is going to be a successful challenge. And lastly, I think, and this is reflecting on something I was told at the start, the whole series was meant to be a rescue mission. There was many things, you know, webinars, for example. Actually, we may roll these out more after lockdown going into the future. No one is suggesting that this exam series was the best way to do things. We should do this again in 2021, obviously. So I think Ofqual had to do something very quickly in a short space of time. And I think a court may well be quite sympathetic to that. again, just to know, wider points will come out in the public discourse. I do think there is room for a wider challenge potentially, but it does have some difficulties. And then lastly, to conclude on the individual challenges, so the broad options for individuals are to, apart from appealing, are to take the autumn series of exams, potentially, to appeal their mark on the grounds of this seminar, and potentially to bring a discrimination claim either through the appeals process to the extent that's viable in the final scheme, or against the school or Ofqual, both of which, as I set out, may be quite difficult. So thank you very much for listening, and I'll hand back to Sam for questions.
Hi, thank you very much, Leon. That was extremely helpful, and I'm seeing that all my colleagues are reappearing on screen. That's great. Right, I sometimes feel with these things that when we build them as a, so we're going to tell you about appeal rights, and people come along and think, well, we'll know what all the answers are, and actually all we've served to do is make things more complicated. But that's not the intention, and certainly it isn't at all straightforward. In fact, only this morning, several of us were engaged in great big debates as to which was the latest version of the guidance, and did the guidance that seemed to apply to this summer's exams in fact apply to this summer's exams, and it transpired that it didn't, and it was all quite confusing. And so certainly we found it confusing, and we've got obviously lots of experience between us of trying to unpick and work out what things mean. I dread to think how other people who don't have to look at these sorts of things regularly are faring. We've had some excellent questions from a variety of people. Thank you so much. And let's see which of these we can answer. I mean, I think perhaps we should start off with a question from Fiona Scolding, who's of course also a QC and a member of these chambers and heavily involved in education matters. And she says, how practical is the deadline for appealing, given the need for the school to bed in the new school year with all the rigmarole that this will involve this year? And that's certainly true. The guidance on returns to school runs to, I can't remember now how many pages, but it is extremely long. And given all the other things that schools will be doing, trying to get pupils to try to work out what they've missed, of course, as a result of being out of school since March. And I think that question can be taken in conjunction with another question that I think I was sent privately about what should schools actually do to try and develop in practical terms so that they can be ready to deal with the sorts of issues that's going to crop up. And I think that the thing that obviously they will be faced with immediately on, having a disappointed student is, the school will have to decide, is this grade, this C grade in maths, is it what we assessed them to receive, or did we assess them to be deserving of a different, presumably higher grade? And so maybe we can start with you, Karine. What are your thoughts about that?
Sure. So the deadline is, as I said in my talk, 17th of September, and we're looking at A-level results coming out on the 13th of August. So there is just over a month in which to bring an appeal. Now, I appreciate that may seem like quite a long time in some respects, but of course, as Fiona says in her question, that's not actually a huge amount of time, given the fact that there may be a large number of students requesting appeals. It's also going to be a time of year where schools are having to get ready for the new year in a year in which there's been COVID, and they're having to think of all sorts of other considerations. And bear in mind that month also includes the internal appeal process. So if a student comes to your school and says, well, I'm not happy with my grade, I want you to appeal on my behalf, and you say no, you have to be able to run the appeals process and have that concluded prior to the 17th of September, in case you are deciding ultimately that you are going to go on and proceed to lodge an appeal on their behalf. So it is a nightmare, but the bottom line is it's the deadline that schools have been given. It's the deadline that has been imposed, and it would be quite foolhardy, in my view, to try to extend that or to not comply with it. In practice, what can schools do? I mean, there are a number of things that they can do. I mean, I know from speaking to a number of different schools that they are ready for this. They've been all keeping, not all schools, but I'm sure most schools have been keeping up with the guidance as best they can. They've been taking advice from their professional bodies, and they are ready for the appeals requests to come flooding in. I mean, there are various schools of thought. You can certainly take steps to ensure that requests are consolidated, that you have proper guidance to students, because otherwise you're going to be flooded with requests which are not capable of actually going anywhere because they're a sort of, I don't like my grade, it's not fair, rather than a kind of the grounds of, one that's based on the grounds of appeal that have been set out during the talks. So it's about, I think it's literally about just being organised, making sure students have got information about the real basis of appeal, making sure that your internal complaint system is working well, and that you can deal with those complaints rapidly. But there's no magic wand solution, I'm afraid.
No, I think that actually the single thing I would say to schools is to get your system in place for managing data, because in broad terms there's going to be two kinds of disappointed student. I'm sure there'll be more, but in broad terms there are two. There's the student who gets a C but was assessed as deserving a C. So that will be, if anything, an internal type complaint. So that's one lot. And then there will be the students who get a C but who were predicted a higher grade, possibly a lower grade, but presumably we're not going to worry about those ones. But those who are predicted a higher grade. And that carries with it, because of the limitations on the nature of the appeals, different sorts of things. And when you need to, seems to me that the reason you need to be able to manage your data is that you need to know whether this concerns one student or whether it concerns many students, whether it's a particular cohort, whether there are certain features about that group who didn't get the grades that your teachers assessed them to deserve, because it's only by knowing what you've got that, and any particular characteristics of those people, that you can work out whether or not there might be a point of trying to either bring some sort of complaint or challenge, or join up with other schools who are finding a similar pattern, because that may well indicate some very systemic and severe problem in the modelling. Now, I realise that we've said challenges to the model are going to be difficult, but it's only by managing your data in a way that is then easily accessible, so that you can have conversations with other people about the outcomes, that you might be able to do things for your students. So the next question, then, let's have a look, is, I suppose, really is, there's a question about students not completing the coursework when the schools locked down in March, and A-level students have received no teaching support since then. And I think it also links with another question that we've had about how can the autumn exam series actually be an answer or an alternative remedy in circumstances where lots of students have had no access to teaching really at all since the end of March. Who would like to respond to that one? Leon?
I can start off and then other people can chip in. So in relation to the coursework, so that's why the view was taken by Ofqual that in the autumn series coursework won't be part of the assessment, because precisely for the reason you say, because when lockdown occurred, some people would have been very advanced for coursework, some wouldn't be very advanced at all, and importantly, some people would have left the school they were at, and therefore they wouldn't have a school to go back to complete the coursework. So so that's exactly that's nail on the head about the coursework point. And I think the wider point that you make, Sam, is absolutely right. How and this is some of the comments this is reflected in as well. When the autumn series occurs in October, students will be at university, or they'll be doing other things, and they wouldn't have had teaching for some months. And how is that fair? And obviously that's a question I don't think legally has been answered yet, and open to anyone else.
Yes, thank you. No, I agree with that. I mean, the system has been set up in such a way it's very difficult to challenge it, I think. Karine, were you waving your hand? No, okay. Thank you. Then looking at, I suppose, the underlying problem, which Dennis Sherwood, thank you. I know you have a very keen interest in this area and have written a lot about it. Is really this, is that the individual student doesn't really care about the process, he just cares about the outcome. And it, I suppose, what else can he do? And I think the answer to that, Dennis, is, I'm afraid, just that set out by Leon in his talk, which is that unless there's some sort of available route via judicial review in the way that Leon set out, the only real alternative is to sit the autumn exam series. I should say that rumours have it, or that in fact the universities are going to be getting the results earlier than normal so far as A-levels are concerned, and that normally I think they get them 24 or 48 hours before the students do, but I've heard that they're getting them this weekend because so that they can start the process of considering to what extent offers will be modified. And of course, whilst the underlying purpose of this scheme and the underlying message from Ofqual is this is all about, it's less about absolute grades and more about enabling progression, that may be perhaps more true in the GCSE context than in the A-level context, where your next step, depends, everything turns on, or may turn on, whether it's an A or a B grade. Yasser, there's a question here from Andrew Harland, picking up on one of your last points. How can anyone appeal against exam body procedures when they write the book and no one has direct insight into the detail, because each exam body has their own delivery system which Ofqual then has to manage? Can you elaborate a bit more about that?
Well, I can try. Thanks for the question, Andrew. Yeah, well, you'll have heard in my talk that on this particular ground of appeal, it was unclear to me what Ofqual were envisaging. And when it's the ground of appeal that's distinct from the wrong data ground of appeal, how does it help anyone if it is thought that actually the right outcome was achieved? I'd be interested, I mean, we can pick this up offline, Andrew, because I'd be interested to hear your thoughts on it, because at the moment I'm not entirely sure how valuable this ground of appeal is for anyone, and I'm interested in the kind of situations that you think it could apply to. But as I said, I don't sure I know the answer to this, and I'd be interested to hear what other people on the panel, if they have any to say about it.
Great. Yeah, I think that the truth is that, as I perhaps foreshadowed at the beginning, some of these questions are very difficult to answer off the hoof, because they will depend on the particular facts and circumstances. There are a whole series of questions about access issues. Is there any advantage in bringing an Equality Act claim against the school, as opposed to putting the evidence to the board to investigate potential malpractice? I mean, that's an interesting question. I think Karine, perhaps, do you want to jump in here, or Leon?
not sure really what I would add. Leon, do you have anything?
No, I don't think. I think that's right. It's amazing. I think the amount of documentation that's come out across the board over this summer. The education. If you just click on the published guidance, it's amazing. Both from the Department of Education and Ofqual, how much has come out, and we're still at a stage where we're waiting a further document to figure out actually how to appeal things. And I think that's just. I mean, that will be the answer to the question. I think, and the devil will be in the detail.
Yeah.
I think that's right. There's a specific question about private candidates, and I actually don't know the answer to this. What are the appeal rights for private candidates? I think, did one of my lovely panel look into this question? And if you didn't, then what I'll say is we will provide some sort of summary response to the questions in a kind of mop-up note, which will be made available in due course. But did anybody look at the position on private candidates?
My understanding, I mentioned homeschooled candidates, for example, very briefly, if that's what meant by private candidates, ones who aren't affiliated to a particular school, for example. Is that the understanding that you have, Sam?
I think the private candidates are normally the people who, where, for example, they're doing a foreign language GCSE because they are half Italian, but the school doesn't normally offer Italian, and so they are entered, I think, by the school as a private candidate. I think that's more.
Okay. Well, in that case, I honestly don't know.
Okay. Right. Great. Well, I think that this has been an incredibly interesting, and I hope you found that so interesting discussion. It's obviously not at all straightforward in circumstances where actually when we started off and when we arranged this seminar about a week or 10 days ago, and thought, well, we'll know the answers to how can you appeal and on what grounds you can appeal. And in fact, that's not the case exactly. It is unfortunate that the final version of the guidance isn't yet available, and hopefully we'll get a bit more clarity. But what we would like to do is thank you very much from all of us for coming today and listening, and we will endeavour to answer any of the questions that we haven't managed to answer in a mop-up document, which we will make available on the Landmark Chambers website. Thank you very much for coming, everyone. Bye-bye.